Supreme Court today, April 8, held that the action of the Governor Dr. R. N. Ravi withholding assent for 10 bills, the oldest of them pending since January 2020, and reserving it to the President after it was reenacted by the state legislature is illegal and erroneous in law and liable to be set aside, and any action taken by Governor subsequently is set aside. The court declared that the bills will be deemed to have received the assent of the Governor when they were presented in the second round after they were passed again by the Assembly. A bench of Justices J.B. Paradiwala and R. Mahadevan held that the Governor having acted not bona fide after reserving for President after the judgment was pronounced by Punjab. On February 10, a bench of Justices J.B. Paradiwala and R. Mahadevan reserved judgment on the writ petitions filed by the Tamil Nadu government against its Governor Dr. R. N. Ravi withholding assent for 12 bills, the oldest of them pending since January 2020. Once the bills were reenacted in a special session by the government, the Governor sent some of the repassed laws to the President for reconsideration. Various constitutional issues concerning the interpretation of Article 200 and factual questions have emerged from the 4 days of the hearing. Bench formulated 8 questions for the parties, including some additional questions which were given today. To briefly summarize, the petitioners have argued that the action of the Governor sitting over the bills for 3 years and then one fine day, declaring that he is withholding assent and when the bills are passed again, reserving it to the President are violative of Article 200. Therefore, the Governor's declaration is held to be void. As per the petitioners' arguments, the Governor has 3 options under Article 200 when the bill is sent to him: assent, reserve for reconsideration of the President and withhold the assent. The state argued that if the Governor reserves it for the President's reconsideration, he has to do so at the first instance. However, if he does not exercise that, the next recourse is to send the bill to the state legislature. Here, it was argued that as per the Punjab Governor's decision which was pronounced at a time when the Tamil Nadu Governor decided to send the reenacted bills to the President, if the Governor was withholding the assent, then he should return the bills to the Assembly. Whereas, the respondent submitted that what troubled the Governor was repugnancy with the central laws and nothing else, and therefore, in the national interest, he sent it to the President. During the proceedings, the court had orally remarked that the Governor had adopted his own procedure on withholding assent. The court had also questioned on the submission of Attorney General R. Venkatramani that the Governor found the bills to be repugnant. It was argued that the Governor by withholding the assent communicated the repugnancy but not for the state legislature to reenact the bills subsequent to which it was sent to the President. The court asked if the Governor had found the bills repugnant, why did he continue to withhold it without informing the Legislative Assembly? Case details: the state of Tamil Nadu v. the Governor of Tamil Nadu and ANR, WPC, number 1239 2023, and the state of Tamil Nadu v. the Vice Chancellor and ORS, WPC, number 1271 2023.
செய்திகளை உடனுக்குடன் தெரிந்து கொள்ள டைம்ஸ் ஆஃப் 3 நியூஸ் சேனலை சப்ஸ்கிரைப் பண்ணுங்க.